It's not there. Yeah. Attendance court, please. The Honorable Supreme Court.
Please be seated. All right, good afternoon, everyone. This is S-1-SC-40136, City of Albuquerque versus Allison. Can I have entries of appearance, please?
Good afternoon, Your Honor. John Anderson on behalf of the City of Albuquerque, Commissioner in the matter. With me this morning at the council table is my colleague Mark Gibson and City Attorney Mark Key.
Marshall Mulvaney, Your Honor, for the Real Party Citizen Trust, and with me today are Loretta Ives and Flores.
Good afternoon, Your Honor. I'm Jerry Todd Worthheim, Joe State Worthheim and Clifford, on behalf of the respondent, the Honorable Joshua Allison.
Thank you, counsel. Mr. Anderson, I note that your time is split 10 minutes for your argument in chief, 10 minutes for rebuttal. Is that correct?
Correct.
All right. And that Mr. Wertheim has been, by way of request, granted 2 minutes, and that Ms. Mulvaney, you have 20. All right. Mr. Anderson, you can take it away.
Good afternoon, Your Honors. If it please the court, John Anderson on behalf of the City of Albuquerque. Your Honors, the city is asking this court to exercise its power of superintendent control to vacate the district court's preliminary injunction. And the city is asking this court to accompany that vacator with authoritative legal guidance, establishing that the Eighth Amendment to the United States Constitution does not operate to bar the City of Albuquerque from enforcing laws intended to protect the public safety and the welfare, even if those laws.
So Mr. Anderson, I'm going to jump in right away because I have more of a, I want to start with the procedural, a couple of procedural things first. You come to the court seeking an extraordinary writ, which requires exceptional circumstances for us to even entertain the writ. And we're only here today on a decision as to whether to move forward essentially or not in some fashion. I'm very curious by the fact that Judge Allison has a hearing set on January the 12th because you all have asked him to modify his order. So makes it feel like, to me, in essence, you're asking us for an advisory opinion at this point because the concrete hasn't set. Judge Allison, you filed a lengthy motion seeking clarification to the parameters of his temporary restraining order. And there's been full briefing, notice of completion of briefing, and that hearing has been set. So that really troubles me as to kind of what are we doing here today. I also note that you have a full evidentiary hearing set later next year. So again, what are we doing here today, given that this is a moving target? Nothing is set in stone yet. We don't, why would we rule now and then have Allison change his order in a way that's meaningful to either party and may have a bearing on the Eighth Amendment question that you seek guidance from us on? I wonder why we're here, other than we invited you, but you asked for the hearing, so.
And thank you for that, Your Honor, and I appreciate it. The fundamental issue in this case is not going to be altered by any amendment or clarification, barring a complete reconsideration by Judge Allison. The fundamental premise that is baked into the preliminary injunction here remains the same. So yes, we do have a hearing scheduled in front of Judge Allison, and we may be essentially nibbling at the edges. The issues that we have presented to Judge Allison really relate to the details and the implementation of the preliminary injunction, with which there are significant issues. But the fundamental issue, and it is one that is of pressing importance to the public safety and to this
So
court.
I understand that as well, but I just found out about an hour ago that there's a hearing on January 12th to clarify this order. And now I'm concerned that we're ruling on something that really isn't, even the preliminary injunction itself is not final in a sense, so to speak, because the judge very well may clarify some of the issues and may change it.
He certainly may well, Your Honor, and those again relate to really the periphery of the issue. For example, the preliminary injunction talks about, well, the city of Albuquerque can clear, for example, a public right-of-way or a sidewalk if there is an immediate threat to public safety. We would be talking about what does that mean? But the underlying premise or the foundation of Judge Allison's opinion, barring a reconsideration in toto by Judge Allison, is going to remain unaltered and unchanged. And that is the fundamental finding that the Eighth Amendment and the Martin and Johnson cases from the Ninth Circuit, that the Eighth Amendment essentially precludes the city of Albuquerque otherwise from prohibiting or enforcing ordinances that restrict the presence of homeless people in public spaces. So
But
we can
wouldn't we then be essentially hearing this case piecemeal? Unless we were to find that there's no Eighth Amendment violation under any circumstance, aren't we just deciding this piece by piece by piece? And shouldn't we just maybe wait until the end, until we have a ruling on the merits and then hear this case?
I don't believe so, Your Honor. District guidance that we're asking this court to issue here would, in the first instance, reflect that the Eighth Amendment does not impose the types of limits, and that would significantly change the scope of litigation in the district court, such that this.
I guess one of the concerns though is, what if one of the concerns about the judge's order is the breadth of how the scope of the ruling on any ordinances, any statutes, pretty much in any public place? What if the concern was more about the scope of the order as opposed to whether it's that black and white that you can never have a cruel and unusual punishment finding in this context? That was such a horribly worded question, and I apologize. But my question is, it's not just whether the Eighth Amendment applies or not, it can also be the scope of the order.
Certainly it can be the scope of the order, and I think that's what gives visibility into what we would be arguing about at the district court. Again, I think we would be nibbling around the edges and talking about the specific circumstances in which a homeless campman, for example, can be dispersed.
Does the city even know, based on his order, what is being enjoined of those ordinances? Could you even, I can't tell.
It does not.
It seems to say the holdings seem along the line of the jurisprudence that's controlling, but the remedies don't. I don't know how the city would know what they can do and what they can't do based on this order.
Well, and it's precisely one of the problems, Your Honor. It's one of the reasons on a marginal level that we have gone back to the district court and asked for that clarification, but it is a more fundamental problem with the very idea of enjoining the city's management of the homeless issue in Albuquerque.
So do you think under this, I have the same concern as Justice Thompson, quite frankly. Because one of the prohibitions is at schools, which I assume is because there's children there. But you go to our community centers anytime during the summer and they have summer school, or they have camps with kids there. My reading of this order permits encampments to be in the area of those community centers unless they're an immediate harm to a person. Do you agree with that? Same with senior centers or other areas where we have vulnerable populations.
Absolutely, Your Honor. And again, I don't even think that the immediate threat language, as I read the order that Judge Allison crafted into it, would apply to that type of scenario because
What's the difference between immediate threat and immediate hazard? I mean, I spent a lot of time with the city's own ordinance, and boy, does it resemble Judge Allison's ruling. And so I'm really curious as to what the city is so befuddled by when the city uses the language. Immediate hazard, immediate threat, it's not a big stretch. And if you think it's a big stretch, you have a hearing on January 12th to clarify that.
Understand, Your Honor, and I guess what I would say is it is a standard that requires discretion in its discharge. In other words, for example, the district court's preliminary injunction talks about you can clear a sidewalk if there is an immediate threat. Well, what does that mean? If we
It
have
says immediate threat to the safety of any person. That's much more narrow. I mean, to me, that's even harder to enforce.
It is, Your Honor. So
Except the city's own ordinance says this. So I don't understand this argument that the sky is falling when the city promulgated its own ordinance that tracks the same exact language and takes language directly out of Martin about the Eighth Amendment and presents it in its own policy for responding to encampments on public property.
I understand, Your Honor. I think it's very different to have that come from an injunction where we're operating under a Rule 65 injunction versus the city's own ordinance where
So
it
the
has discretion
city-
to enforce.
So the city can take this, do with it, follow it or not, and you're worried that the judge is saying follow it.
I'm worried that the city is under pain of contempt to follow an injunction that does not make clear the specific conduct that is required to follow under an
That's
injunction.
consistent with what the policy makers of the city of Albuquerque have set forth in their own policy. So this fear of contempt, so that means your client has passed this policy. And they're like, well, it's not worth the paper it's written on because we may or may not follow it, but now we're worried because a judge has said, do that which you've laid out in your own policy. That
Well-
doesn't make sense to me.
Your Honor, I think there is going to be discretion in the city's interpretation of its own policy. Again, I think it is a different scenario when we're operating under an injunction issued by the district court on pain of contempt. There is, I believe, built into the policy, there's got to be discretion as to how to apply it. So we come back to a scenario where pedestrians are being forced into the street because of a homeless encampment. Does that present the type of immediate threat to the safety of any person contemplated in the injunction? Does it depend on the amount of traffic in the street? Does it
So
depend
let
on?
me ask this, and it says any statute or any ordinance, so that means criminal trespass under the state statute
Enjoined.
is enjoined, is that right?
Being in the public, enjoined. Defecating
Urinating in
enjoined.
public, enjoined. I mean, I don't understand, this says any statute and any ordinance, so how do you determine which ones apply and which ones don't, and does that apply to future things that might pass this legislative session?
I agree those are all significant issues, Your Honor. It talks about their presence on public space, and we can also talk about their property on public space. I see my time is almost over, so I will stop talking.
You can finish answering any question of the court.
I'll be a little more specific. It is interesting that there is a very definite city ordinance that does not seem to be followed as part of the particular remedies. But the memorandum opinion and order seems to go a lot broader. I guess in the short time left, what is the city's understanding of their obligations under the MOO that may be different than their obligations under their own ordinance? Is it broader, narrower, or the same?
I think it is significantly broader than what the city's obligations under its own ordinance would be, Your Honor. That is the short answer to the court's question.
What's our standard of review?
Well, Your Honor, I think on a writ of superintending control, it's a different standard. I think under a writ of superintending control, the court needs to look at, is it a question of first impression in New Mexico? Is it one that counsels in favor of an early resolution?
That's not a standard of review, that's a test, that's something different. But when we're reviewing a preliminary injunction, which is temporary in nature, it's an abuse of discretion.
That's correct, Your Honor.
So the other test that you're laying out is not the standard of review.
I understand it's not a standard review. I'm differentiating where we are in the writ of superintending control, but yes, you're correct. Thank you.
Mr. Wertheim.
May it please the court, I'm Jerry Todd Wertheim, and I represent Judge Allison.
Did he conduct an evidentiary hearing?
He did not.
Okay.
In the sense that there were not live witnesses.
Okay. And there's one month later, apparently. Is that right?
There is one now set for January 12th, Your Honor. I did review the record because I did notice, and obviously we didn't file a response. This is preliminary relief. We want to maintain fastidious neutrality in this. But I did think it was interesting, the claim that there was a request for an evidentiary hearing and then statement that one wasn't requested. My review of the record showed it's about 9:08 in the morning on the September 8th hearing, was that Judge Allison did ask, if you all need any evidentiary hearing, let me know, bring it up. At that point, the city did not take the opportunity to say, we have witnesses in the hallway, we have something that Judge Allison might do. Mr. Anderson did bring it up on his presentation and said that he thought an evidentiary hearing was necessary.
But it's critical to our analysis. For example, if you're looking at whether or not, first of all, was a class ever certified?
No, that's one thing I want.
So when you're looking at one of these, and I'm in a rush because you got 2 minutes, so I apologize. I don't mean that.
Sorry,
It's not meant towards you. It's me just trying to get a question out. Real quick. There's a couple of the petitioners, right? And it depends whether they have a constitutional claim or not as to whether they were obstructing traffic with their carts or they were arrested for being unhoused. That is significant, but it's disputed. So it's really rough. It's difficult to reach the constitutional question without the factual predicate. That's all.
I think that's right, Your Honor. And just to let you know, there is a class certification motion on request of the plaintiffs now set for January 25th. So there's the evidentiary hearing on the 12th, class certification on the 25th.
So I thought the hearing on the 12th was motion to seek clarification on the preliminary injunction and the evidentiary hearing set next year. I might be missing something. As I said, I just found out these
Yeah,
hearings.
my
even-
understanding, and the motion, my understanding is this is a current request for a clarification and modification of the currently existing preliminary injunction.
Thank you.
Ms. Mulvaney.
Madam Chief Justice, and may it please the court. The city has petitioned this court for emergency relief based on a gross misrepresentation of the facts and the law in this case, as well as a mischaracterization of the consequences of the district court's carefully considered preliminary order. The city's petition should be denied, and the two topics I'd like to cover today are: first, I'd like to explain why this court should decline jurisdiction to hear this matter now. And second, I'd like to explain why, if the court does decide to accept jurisdiction, it should deny the city's request for a stay. Now, the record in the district court establishes that there is not enough housing in Albuquerque to support its population, that many people in Albuquerque are too poor to afford housing, and that there are
So
not enough shelters.
as to that point, Does this record demonstrate that every night these shelters are full and there's no room for any more people to come in? Is there evidence showing that?
No, Your Honor. What the evidence shows is that,
Just looking at raw numbers.
yeah, in terms of raw numbers, yes.
So what? If I have a bed available and I choose to remain on the street, does that mean that the judge should now rule that I am one of those that don't have a bed available to me?
No, Your Honor, and the judge did not rule that. What the judge ruled is that because on any given night, there is some percentage of the population who has no indoor place to stay, that
By
for,
choice or by circumstance?
by circumstance. So,
How
and-
many?
so Your Honor, the city contended that it has 1,192 shelter beds, including those in the West Side shelter. The most recent point in time count demonstrates that there are approximately, the count itself had about 2,500 people who were unhoused. And the organization that conducts the count suggests that the actual number is likely 2 times as high. So on any given night, there are people in the city of Albuquerque who have no place to go. Now, so for anybody who
There's no evidence demonstrating.
there is, and the evidence that demonstrates it is that there are not enough shelter beds. And so,
But are the available shelter beds full such that someone else has no bed available?
no, so Your Honor, the way that question gets addressed is at the time of enforcement. So what we know is that we need,
So let's talk about the time of it.
yes,
This order is replete with phrases like mere presence,
yes,
unavoidable consequence of being homeless, abandoned property, unabandoned property, but it's left in a public place, whatever that means. But the thing about mere presence or merely existing, what does that mean? I don't understand what that means, because it sounds like they're just there.
exactly, Your
And
Honor.
they're not doing anything, they're just there.
Exactly, Your Honor. And that is what it's directed at. So when Justice Thompson was concerned about public defecation, public urination, this injunction does not cover that conduct.
Are you,
And that the city of Albuquerque is hereby enjoined from enforcing or threatening to enforce as a means of seeking compliance with any statutes and ordinances against involuntarily unhoused people.
That
Unless it's an
criminalize their
immediate threat to
presence.
health.
No,
to the safety, not health, safety?
I beg your pardon, that it is directed at their presence on public property with their belongings. That is the limitation in that paragraph. Presence on public property with belongings. So those include statutes like and what we're talking about is the factual predicate. We're not, because this is a as applied challenge and not a facial challenge to any.
This isn't a, okay, I'll let you.
Yeah, so it's not a facial challenge to any particular statute or ordinance. These are otherwise valid, generally applicable statutes and ordinances, such as trespassing on public property, obstructing a sidewalk, being in a park after hours. These are statutes and ordinances that are totally appropriate to enforce against people who have some.
But your injunctions to opposing counsel's question was based on an allegation that the plaintiff was arrested for one thing and not the other, and that finding was never made. That's the problem, I mean, the last time I checked, we don't decide things administratively. These are factual questions that the court needs to determine to see if this rises to a constitutional question as you just described.
So what the court has is a deep factual record for purposes of a preliminary injunction. Of course, there will be more evidence at trial. And
Then
that's
why shouldn't we stay at pending the evidentiary hearing where that determination could be made?
The reason that this court should not stay this injunction pending an evidentiary hearing, well, there are a number of reasons, but one, Your Honor, is that it is cold outside, and the injunction is designed in part to prevent the city from causing unhoused people to freeze to death when the city robs them of their tents, blankets, and clothing and to go without water, food, and medicine when the city confiscates their other property.
And I don't want to focus on I have less of an issue, and I didn't hear much argument on the confiscating and having a
Yeah.
hearing on the property. I don't see that as problematic. It's more the first part,
Okay,
the cruel and unusual punishment finding,
so
giving me pause.
yes, and because citing and arresting people for their mere presence outdoors with their belongings, this is not any other conduct. This is not defecation. This is not urination. This is not drug use. This is when a city police officer sees a person on a sidewalk with her belongings and says, this is a criminal offense. This is obstructing a sidewalk, or this is trespassing.
Why do you believe that the court made public schools an exception? They said you can't occupy a public school property.
Because in the district court, the city expressed concerns about the potential scope of the injunction. And plaintiffs absolutely agreed that the city has a legitimate interest in ensuring that unhoused people and their belongings are not on some locations on public property, so long as there are ample other places for them to be. So for example, Your Honor, if the city wants to say, for example, unhoused people can't be in parks, they can't be here, they can't be there, all the city has to do that and meet the constitutional standard is show that there are ample other places for them to be. So for example, the city
You
could.
mean ample sheltered places or?
No,
unsheltered?
outdoor. So all the city would have to do is say, for example, there are these 12 city-owned vacant lots around the city. And then it would be a factual question for the district court to determine whether that's ample enough to justify the other limitations.
Can I take you just slightly somewhere else?
Yeah.
So the Robinson versus California, the US Supreme Court case, struck down a law that made it a criminal offense to be addicted to narcotics. And that's where the status portion came in, but it was supposed to be used sparingly. Martin's a Ninth Circuit case. We're not bound by that case. Why don't you believe that the Ninth Circuit took Robinson too far? In other words, why does the Eighth Amendment even apply here? Because if I'm housed and I trespass, it's a violation. It's the conduct, not the status, that's being prohibited. So I don't quite see them the same.
So Your Honor, the reason that being unhoused, so you're correct that in Robinson against California, the US Supreme Court told us that a government cannot criminalize a person's status. And in that case, the status was the status of being addicted to the use of narcotics. Now, in Powell against Texas, that principle was extended. And in Powell against Texas tells us that a government cannot criminalize conduct that is sufficiently
Powell
proximate.
versus Texas was a plurality.
So that is correct, Your Honor. And the controlling opinion under Marks against United States is Justice White's concurring opinion. And Justice White's concurring opinion tells us that a government cannot criminalize conduct sufficiently proximate to a person's status. And so in that case, that was drinking for a person who was alcoholic. Now, courts across the country, and not just in the Ninth Circuit, have applied these principles to conclude that a government cannot punish unhoused people who have no indoor place to be for being outdoors on public property with the belongings that they need in order to survive. And so that's not 20 carts, it's just whatever is essential for them to.
But there's
sustain
some
life.
things that are crimes that don't involve an immediate threat to the safety of any person. And now individuals who are unhoused the city's enjoined from enforcing those.
So the city is only enjoined from enforcing any statute or ordinance where the conduct at issue or the factual predicate at issue is the person's mere presence on public property with her belongings that she needs in order to live. And back to your question about why isn't that conduct? The reason that it's not conduct, so even courts that have adhered to some kind of strict status conduct distinction have concluded being unhoused is a different category. It's not like drinking. Even for an alcoholic, A person is not drinking 24 hours a day. You know, even an alcoholic, in theory, the person could choose not to drink. An unhoused person who literally has no indoor place to be cannot but be outdoors on public property. She can't be outdoors on private property. She must be outdoors on public property. And as human beings, we need certain personal possessions in order to survive. We need some modicum of shelter, we need clothing, we need food, we need water.
And I hope that everyone in this room understands that there are a great number of people who are unhoused and they don't have a choice about it. It's not the person who says, for example, I have been unhoused for so long, I can't stand to be in four walls, or somebody who's addicted to, meth, who says, I'm not gonna follow societal norms. There are hundreds and hundreds of people in the city of Albuquerque who don't have the means, because housing is so expensive, to be housed. So where else would we put them? I think is the quote from Martin and other cases. Where else can they be?
That is correct, Your Honor.
And I hope everybody understands that basic
So
tenet here.
assuming you've got a public lot, publicly owned lot, and it's abutted by a public sidewalk, does being homeless under the circumstances described by the chief give you a right to sleep on the sidewalk as opposed to being in the field?
Under the current injunction, it does, unless your presence on the sidewalk creates a threat to the safety of any person.
So there, if a sidewalk was not used by pedestrians, like just to try and put context to this, if it's in some part of the city, nobody ever walks down this sidewalk, it's against a road that's not used, widely used by traffic, I guess the argument would go, that person, even though there might be on the sidewalk as opposed to the field, doesn't present that problem. But if it's somebody on the sidewalk in Nob Hill, the police could then make the assessment and say, this is blocking the free flow of traffic, it's a tripping hazard, somebody might fall into traffic, et cetera, and therefore it's not allowed on the sidewalk.
Yes, and again, under the scheme that Judge Allison set up, this is totally within the city's control, subject to the constitutional limitations and the oversight.
So can I ask a
Allison.
question? I want to be careful. In Martin, there were two ordinances that were really focused on. I think it was the disorderly conduct ordinance, although it seemed more like a camping ordinance based on the language, and one other. Here, it applies to any statute or ordinance, and it enjoins the city of Albuquerque from enforcing any statute or ordinance, past, present, or future. I mean, I just worry at what point does the judiciary take on the role of implementing policy to address this very, very complex problem versus leaving it in the hands of our lawmakers?
Yes, Your Honor. So it would be wonderful if our lawmakers, or if the city of Albuquerque addressed the problem of homelessness in a way that did not violate people's constitutional rights. What the judge in this case did was ensure that the city of Albuquerque respects the constitutional rights of the unhoused. And
doesn't the city's own ordinance, I'll take language from it, the city recognizes and embraces that it must give equal protection to the unhoused, notice, due process, and this is the piece that I find very interesting because it comes right out of Martin, and has to be confident or understand whether there are enough shelter beds to house everyone who is involuntarily unhoused. Isn't that come straight from the city's own policymaking?
yes, and unfortunately, the court found that the city is not following its own policy. Your Honors, in my remaining time, I'd like to turn to the question of, I'd like to turn to my second point, which is that if this court decides to accept jurisdiction, it should deny the city's request for a stay. To the degree that the city claims that the preliminary injunction causes any harm to it, the city has a means to mitigate that harm in the district court by seeking reasonable modifications of the preliminary order. In contrast, if this court stays the injunction, unhoused people in Albuquerque will be helpless to mitigate the harm caused by the city when it cites or arrests them, hounds them from place to place when they have no place to go, on threat of criminal prosecution, or when it seizes and destroys the very belongings that they need in order to live. And it's important to keep in mind that in granting this preliminary injunction, the court made factual findings, both that unhoused people in Albuquerque are likely to suffer irreparable injury in the absence of an injunction, and that the irreparable injury to the unhoused people outweighs any harm the injunction causes the city. Now, if this court were to stay
How
the
would-
injunction,
And I'm thinking about this, and again, I don't really have a problem with the property provisions.
yes.
I understand that. But with respect to the cruel and unusual punishment and the method in which the city's enjoined, how would an officer go about determining whether someone's involuntarily unhoused? What if it's a 17-year-old that looks like a 25-year-old that runs away and decides to camp out because his parents made him mad? I'm just, like, how, it almost feels like profiling, for lack of a better term. I think that person's involuntarily unhoused versus maybe someone else. How would they go about enforcing this
Yes, Your Honor.
or
So-
identifying that without violating rights? Because it's gonna apply to the people that are housed. The
So,
criminal
yeah.
trespass still applies to me and you and everyone
That's,
else.
that's correct, Your Honor. So as with any other criminal offense, the standard for doing, the city can just investigate without any kind of detention. Brief detentions require reasonable suspicion. So if the city has a reasonable suspicion that somebody is voluntarily housed, the city can also approach people consensually. Consensual encounters are appropriate. And based on the evidence of the numbers of unhoused people in Albuquerque, the city must assume that people are involuntarily unhoused, where the numbers show that there aren't enough beds for people. If the city wants to investigate further, it can. And also, if the city wants to offer somebody a bed that is actually available, the city can do that also. It's not required to by the injunction, but it can. And then if the person refused, then the city can enforce its laws against that person, for their presence on public property with their belongings.
Can I ask you a particular narrow question on this population-wide formula concept that you were talking with the senior justice about that sort of bases the Eighth Amendment violation? Can you cite authority to another jurisdiction that establishes this test? Johnson versus Grant, which is a case I think on which you rely, majority opinion goes back on that test, it seems to be. Is there any other jurisdiction that for this purpose applies this population-wide analysis? And if that's hard to recall, what is your view of Johnson versus Grant pass on this test?
So both Martin and Johnson and the city of Grants Pass use this sort of test. And the test is not a per se test. It doesn't mean that everybody who's out on the street therefore is in fact involuntarily unhoused. What it means is that there is that what it establishes is that there is some number of people who are involuntarily unhoused. And that then when the police encounter an individual, if they then determine that that person is not involuntarily unhoused, that's when they can enforce.
So it doesn't determine whether there's no other place available. I understand your argument to be, you take this population-wide survey and that itself proves that there's no shelter place available as the exchange with senior justice. That is not your position.
So our position is that what it establishes is that there are more unhoused people in the city of Albuquerque than there are shelter beds.
Okay.
It doesn't establish anything for any one individual. Any one individual, that person might be able to go to their moms. We don't know. So these at the time of enforcement, it's a factual question. But in terms of the evidence necessary to demonstrate that there are more unhoused people in Albuquerque than there are beds, such that the city's practices violate the constitutional rights of at least some portion of.
The whole class of people.
Yes, That's right. So it's an injunctive class seeking prospective relief, Your Honor.
Thank you. Thank you very much.
Bless you.
Do I?
You are out of
I beg your pardon.
No, I always let people
my fault.
finish the final question, so don't worry about that. But thank you very much.
Thank you, Your Honor. Your Honors.
Mr. Anderson.
Thank you again, Your Honors. And if I may, let me pick up on what I think is the status conduct distinction that the court was discussing with Ms. Mulvaney. I think there are a couple of implications here with respect to that distinction. And one of them does relate to the formulaic or formula analysis that the district court seems to be proceeding under. And Justice Vigil, Ms. Mulvaney had an exchange with you about the number of shelter beds. There is not evidence that on any day that West Side Emergency Housing Center or that the city's emergency shelter beds have been full. So we are not in a position where we can simply group the people who are homeless and call them all involuntarily homeless because
But isn't that in part an argument for later? I mean, you've got a class certification hearing coming up to discuss whether this can be bundled as a class or not. And it's more, I agree, it's more complicated than saying the West Side Shelter had 3 available beds last night, because remember, the unhoused typically don't have cars and can't drive themselves there. It's that it's available to them in a meaningful way. And we know by definition that there are people in Albuquerque who are unhoused, who cannot avail themselves in a meaningful way of the West Side Shelter because it's on the West Side.
Well, Your Honor, that is there are factual questions to be explored, and that's certainly in the class certification context. But again,
I think
we're
there's
here.
questions about the scope of the class, but I don't think, I mean, please tell me, does the city take the position that there are X number of unhoused people in Albuquerque tonight, and there are enough shelter beds in Albuquerque that it can meaningfully take advantage of tonight, doing the point in time analysis?
I think it's a factual question that would turn on a lot of things. There is transportation out to the West Side Emergency Housing Center, for example. But again, we've never been in a situation where those beds are full. We have never been in a situation where the WEC is turning people away because of a lack of beds. And again, we can get to a situation where, supporting the preliminary injunction, there was no evidentiary hearing, and the city did ask for an evidentiary hearing.
But it's not mandatory for a preliminary, cite me to a case that says it's mandatory for a preliminary injunction.
I'm not suggesting that there's case law that says it's mandatory.
But you seem to hang your hat on that in the briefing, and some of my colleagues seem to hang their hat on this idea of like, oh my God, the sky is falling. We haven't yet had an evidentiary hearing. That's what the hearing later on that you guys have entered into a scheduling order on and said, we want time to disclose our experts and do discovery and have a trial. That's the normal process. So this idea that you didn't have people under oath live testifying in front of Judge Allison really doesn't hold any water for me as a civil judge who handled these cases all of the time, and they were rarely full evidentiary hearings at the temporary stage. You still have that opportunity coming up in spades, in fact.
Well, I understand that, Your Honor. I think the record could have been certainly fleshed out more with an evidentiary hearing and some of the
The
questions.
3 hours you had to argue in front of Judge Allison wasn't enough?
I don't think it supported, obviously, the adducing of additional evidence that would have borne on the questions to be resolved in the context of the
What
preliminary.
testimony would you have presented that wasn't already presented to him by way of deposition? And I want something very specific, because you all put in a whole bunch of sworn testimony that Judge Allison reviewed.
Well, Your Honor,
And he looked at it and said, I'm not buying it. And he's allowed to do that at a temporary restraining order stage, at a preliminary injunction.
I understand that, Your Honor. I think there could have been testimony establishing from the plaintiff's witnesses that could have been subject to cross-examination to explore some
You
of
had
the
them under
statements.
oath at a deposition.
I don't think they've been deposed yet, to my knowledge. Now,
But there were depositions, at least from your side, put into the record.
there were affidavits.
Or affidavits, I'm
There
sorry.
were
not depositions,
affidavits.
But affidavits, and that's typical. So if we turn this upside down and say every preliminary injunction has to have a full week-long trial, we are turning upside down for the trial courts, how we approach preliminary injunctions in the state of New Mexico.
And I'm not asking the court to issue a categorical rule that every preliminary injunction needs to be supported by an evidentiary hearing. What I'm suggesting is that to the extent there are questions here that could have been resolved or could have been shed light on in the district court through an evidentiary hearing, that would have been a beneficial thing, and it's something that we asked the district
And do
court to
you
do.
think it would be I agree, I don't think a hearing is needed at all. I don't want to suggest that. But when you enjoin an entire police department from enforcing any statute or any ordinance in the manner that it has been enjoined, I'm just wondering why we wouldn't have an evidentiary hearing. Do you believe that that might be why it's important to have one in this particular case?
I do, Your Honor, and the district court, indicated the gravity of what he was doing in enjoining the state's largest city from enforcing a large cross-section of its laws. And again, we did ask for that evidentiary hearing.
And when we talk to 2 points here. First, when did you ask for that evidentiary hearing? Because as Mr. Wertheim has pointed out, the judge started with that and heard nothing. And second, when we're looking at the language, the injunctive language in the MOO, I refuse to use the shorter term, in the order, it says any statute and ordinance against involuntarily unhoused people that prohibit a person's presence in outdoor public spaces. So it's not any ordinance, it's not any law, it's those that prohibit a person's presence in a certain very well-defined place.
That's correct, Your Honor. Let me
Okay,
answer
'cause
the.
it seemed to be argued a little broader.
And I want to touch on that if I may.
Yeah.
Let me answer the court's first question.
Please do.
We asked for that at the, and I don't have that audio in front of me. My recollection is that we asked for that. Judge Allison did open the hearing by saying, does anybody think an evidentiary hearing is necessary? I indicated that I did believe one would be necessary. And Judge
Mr. Anderson, isn't the real issue whether the petitioners, the plaintiffs actually met their burden under a preliminary injunction standard? You're arguing that we should have been able to put on more evidence, we should have had this evidentiary hearing. Isn't the real issue, what you're really trying to get at is that they didn't meet their burden, or we didn't have an opportunity to rebut their burden? So it really has to do with the burden, doesn't it? And for me, the thing that I keep getting a little bit caught up on is because there are all of these factual disputes between the parties, whether people were throwing rocks or whether they were just sitting on the sidewalk, whether the city was enforcing or not was threatening people or not threatening people, is a factual dispute. And for me, it really comes down to the likelihood of success at the trial on the merits, which is the final element. Aren't we really talking about that? Not whether you had an evidentiary hearing or didn't have an evidentiary hearing?
I agree with you, Justice Vargas. There are fact questions here, and you're right. The analysis is ultimately under a 4-part test for a preliminary injunction. Where we are looking at here is with a focus on the likelihood of success on the merits and where the public interest falls inside of that preliminary injunction calculus. And I want to be clear on what we are talking about here. When Chief Justice Bacon talked about mere presence, yeah, we're talking about mere presence, but look at a situation like we have at Coronado Park and we had during COVID at Coronado Park. And we have extensive evidence in the record detailing all of the ills that flowed from that situation. Again, violent crime, drug use, theft of electricity, hygiene problems. There was a situation that the city was ultimately compelled to come in and disperse that for the good of the entire
And that was,
community.
at that point in time, was consistent with the city's policy. And what happened in Coronado Park is still available to the city under this restraining order
I don't
because you
agree.
can. How is that not an imminent threat to safety? Needles in a park, public defecation, guns, you name it. All of that fits within Judge Allison's restraining order. You can still clean out Coronado Park. You don't need to now because the city flooded it and moved everybody, which was an interesting approach. But this restraining order doesn't preclude that.
That is not the way I read it. I read it as saying public rights of way. You can clear public rights of way in the event of an immediate threat to any person. But as I read that injunction, there is no language in there.
Are you ignoring paragraph 49 that precedes the injunctive language? And then the injunctive language it it says, it's enjoined from enforcing those things that fall outside of paragraph 49. When a homeless person obstructs a public space in a manner that poses an immediate threat to the safety of any person, and the city documents and makes a written record of its findings of the immediate threat to the safety of others, the city may do that.
Well,
It uses the may. I circled it and highlighted it 3 times.
if the situation is such that there's an immediate threat, I guess I question the scope of what we're dealing with here, because I don't understand that memorandum opinion and order to be permitting a clearing of a situation like Coronado Park, and certainly I don't think it would.
I completely disagree with you, with the city's reading of it, because I believe that this allows the clearing of Coronado Park.
See my time.
Just one question. I know it's over time,
Unless
but,
it takes me to another question.
well, I'll do my best. I'm
Okay.
trying to read your mind.
Been very quiet.
I'm wondering if you can address the Eighth Amendment and the status issue, because I think that's a central issue before we get into kind of all of these other issues.
Certainly, Your Honor. In the first instance, the way that I would answer that is that the Eighth Amendment does not preclude the city from enforcing its laws of general applicability. The New Mexico Court of Appeals has spoken about the Eighth Amendment being a limitation on the type of punishment that a state or municipality can impose. But let me move to the status conduct distinction. Certain things, regardless of how we come out on that question, there are certain things that are clearly fall under the conduct side of the Eighth Amendment. So for example, Ms. Mulvaney had talked about mere presence and merely existing. It's certainly not inevitable to exist in one particular place, so that the city could close a park, for example, and say, you may have to sleep somewhere, but you don't have to sleep in this park, or you don't have to sleep in the arroyo. You're not allowed to sleep on the tennis court when people have reserved that. The other piece is you don't have to, we saw in Johnson, limitless belongings. There's evidence in the record of people with 15 shopping carts at Coronado Park. Certainly, the Eighth Amendment does not preclude the city from imposing limits on the amount of property that one may have there. And finally, a length of time. Again, Coronado Park was a situation for a couple of years. Nothing in the Eighth Amendment precludes the city from imposing limitations on the amount of time people may remain in one place. And I don't know if that answers your question, Justice Zamora, but.
It did. Thank you. Thank you.
All right, council, thank you for your presentations today. The court will take this matter under advisement. In recess.
Agenda board